Hello guys, my name is Krish and in this video I will discuss the case of Sajjan Bank Private Limited versus the Reserve Bank of India. In this case, the petitioner bank was incorporated in the year 1944 with the main object of carrying on the money lending business. Now in the year 1949, Banking Companies Act is enacted by the Parliament and there is a specific provision, that is section 22, which makes it mandatory for all the banking companies to get a license in order to run the banking business. Accordingly, the petitioner bank applies for license in the year 1949 and in the year 1952 the RBI conducts an inspection. In this inspection, the RBI finds that there are some defects with the bank due to which the license should not be granted, but the decision was not made at that time and the decision was kept in abeyance. Now, a correspondence is made between the RBI and the petitioner bank regarding these deformities, and some time was given to the petitioner bank, to correct these infirmities. Another inspection in the year 1956, that is after 7 years of the first inspection, is conducted by the RBI under section 35, and in this inspection also there are some deformities which was found by the RBI, and therefore a show cause notice is issued to the petitioner bank that why license should not be denied to you. After considering the representation made by the bank, the RBI came to conclude that the license should not be granted and the application was rejected in the year 1957. Now the petitioner bank moves the High Court under the writ of certiorari and raises three main contentions. First of them was that Section 22 of the Act is unconstitutional on two aspects. First, that it violates the fundamental right to trade or business, and second, that the power vested in the RBI is arbitrary and therefore it is not a license but a permit. Coming to the first aspect, the court observed that the provision, that is section 22, it regulated the banking services. What is banking service is defined in section 5B of the Act, that accepting of deposits for a limited purpose, that is of investment or lending, accepting of deposits for limited purpose which is repayable at demand otherwise. But the main object of the this petitioner bank, the main purpose for which it was made, was the money lending service. There is a difference between these two. Banking service, you are accepting the deposits of general public, and then that deposit is lent or invested. But in money lending services, you are not accepting the money from general public. Therefore, in money lending service, your own risk is involved. But when the banking service you are carrying on, you are accepting the deposits of the general public and then investing and lending that same to others. Here the risk of people is involved. Therefore, here comes the reasonable restriction of Article 19(6) that states, for the benefit of people, the state can impose restrictions. Therefore, this was reasoning why it is not the violation of 19(1)(g), as it falls under the scope of reasonable restriction. The second aspect raised by the petitioner bank, was that it is permit and not license. So there is a difference between these two terms. The court actually negatively defined the permit and stated that why it is not permit, because of four reasons. That first, there is existence of rules for guiding the authority. Second, the refusal of license is based on reasonable grounds. Third, there is provision of right to appeal against the decision. And fourth, the inspection was actually judicial inspection based on the reasonable grounds that are already mentioned in the statute. Therefore, it is not the arbitrary or whims and fancies of the RBI according to which it is accepting the application and rejecting the application, but it is a proper mechanism through which the RBI goes in order to grant license or not. Given this reasoning, the court held that it is not a permit but a license. Therefore, it is not unconstitutional. The second contention raised by the petitioner bank was that the action of the RBI was arbitrary. But the court observed that there were two inspections held and ample opportunity was given to the petitioner bank to rectify its defects. The first inspection was held in the year 1952 and all the deformities were corresponded with the petitioner bank. And the second inspection was done in 1956. There also same deformities were faced by the RBI concluded that same deformities still exist and no improvement has been made by the petitioner bank. Therefore, an ample opportunity was provided to the petitioner bank to rectify its deformities, but no improvement was made. And therefore, the RBI found that the operation of the banking company is detrimental and as mentioned in section 22 subsection 3 clause B of the Companies Act. Now coming to the third contention, the petitioner bank contended that the procedure adopted by the RBI was illegal because the second inspection was conducted under section 35, but the result of the inspection was that the petitioner bank was refused to grant a license, and this power is actually vested by section 22 and not by 35. Therefore, if the inspection is conducted by 35, the result can only be in consonance with the provisions of 35 only and not 22. But actually this judgment is silent on this contention. But what I came to conclude is that the main object behind conducting the second inspection under section 35(1) was only to find whether the petitioner bank has made any improvement with its affairs or not, and ultimately to decide the application of license made under 22. Therefore, the court held that the section 22 of the Impugned Act is constitutional. Additionally, the decision taken by the RBI was legal, and also the procedure followed by the RBI in coming to that decision was also valid. So this was the case of Sajjan Bank Private Limited versus the RBI 1961. And if you want to know more about similar judgments, then do subscribe to my channel. Thank you.